wages is the definition of wage and what it really means,
Yeah,
how this is going to
I will
affect
take
and
this
impact.
opportunity, Anima. It's
Sure, sure. Please
the
go ahead.
this is the industry's pain area, and everyone is been having the myths about how the wage has been there, what is the wage, how the wage has been designed. A very important thing. So the for the clarity, what the government has been clear for the labor, all the labor enactment, like 29 labor enactment, now they have clubbed to the four labor laws, labor codes. What they have tried to design, they have designed the salaries and the interpretation of the law commonly for all the labor laws. So when we talk about the salary of the wage, earlier the salary of the wage is different for ESIC, although ESI have a different limit. And this the definition for the wage is different under the Provident Fund Act. The definition of the wage is different for the Minimum Wages Act. The salary for the wage definitions under the Bonus Act, it is different. Now the department have created the common wage definition across all the labor codes, or you can say all the 29 labor enactments, for the sake of understanding and for the better clarities and the confusions. And they have also put certain rights with them, so that which they want to be employed in future as and when they found necessity of that. The first I will simple read the definition, then I will give you the interpretation of the law. The definition of the wage in the wage code, it will under the section 2y, under the code of social security it is under the 288, but the definition remains same. Means all remuneration, whether by way of salary, allowances or otherwise, expressed in the terms of money or capable of being so expressed, which would, if the terms of employment express or implied were fulfilled by payable to the person employed in respect of his employment or of a work done in such employment, and includes basic pay, dearness allowance, retaining allowance, if any, and does not include. They give the long list what does not include in the wage. They include any bonus payable under any law for the time being in force, which does not form a part of the remuneration payable under the terms of employment. Means any bonus amount which you are paying on a monthly basis, it will not considered like a part of the salary. Second, any value of the house accommodation or supply of light, water, medical attendance or other amenities or any services exclude from the computation of wages by a general or special order of the appropriate government. There are certain industries, those are giving certain values of the accommodation concept. For example, the if you are taking the house of the company's owned properties, so you have been given the house accommodation allowance, or if you are not using that property, you are not giving the house accommodation allowance. So they talk about that only. C, they talk about any contribution paid by the employer to any pension or provident fund and the interest incurred thereon. So now when they talk about the interest incurred thereon, they talk about the NPS, what we interpreted. When they talk about the pension fund, means maybe the contribution you are paying for NPS. Provident fund is the employer contribution, and the other part. Give me a second. Give me a second. Okay.
Sure. So I'll just continue with the exclusions. As our Sir has reached clause C, which includes the interest which may have accrued thereon, the conveyance allowance or the traveling allowance, any sum, the clause E, which is
I
paid
think
to
there is a
defray.
network problem in your system. Animaji, please continue.
Yeah, sure. Employed person to defray special expenses entailed on him by nature of his employment, the house rent allowance, the remuneration which is payable under any award or
Animaji, are you
settlement.
there?
Yeah, am I not audible? Hello, am I not audible? Am I not audible? Hello,
Animaji?
hello, am I not audible? Am I audible? Hello. I can hear you.
Sorry, am I audible, Anima?
Yes, loud and clear,
Yeah,
sir.
sorry, I missed it in between. Sorry. Okay. So now when we talk about the pension fund, here the department want to say that the contribution paid to the employer is been not a part of the wage. For the example, for the past of the cost to company, any conveyance allowance paid to the traveling concessions, any sum paid for employee for different special expenses. In short, you can say it special allowance or other allowance. The other another is the house rent allowance, remuneration paid for the settlement, and the for the between the parties, any overtime allowance. Here is a big ambiguity on the overtime allowance. Any commission payable to the employee, any gratuity payable on the termination of the employment, any retrenchment compensation. They have categorically defined these all are categories which are not to be considered as a wage. These are being excluded from the wage definition. They have outrightly said. And on the next slide, we will tell you. Okay. The now they have a certain provision in that. They provided that for the calculation of wages under this clause, if the payment made by the employer to the employee under clause A to I exceed 1.5 of such other percent, may be notified by the central government, or such exceed the 1.5% so notified shall be deemed as remuneration and shall be accordingly added in the wages under this clause. What they want to say, they want to say the all the allowances which we have mentioned in the categories of the exclusions from A to I. You can check it in A to I. A to I, yeah. This all these total of this A to I, like bonus, house rent, PF contribution, conveyance allowance, special other allowance, house rent allowance, remuneration pay as a settlement, overtime allowance, any commission payable. If the total of A to I is more than 50% of the basic DA and retaining allowance, that is to be considered a wage. That means they have outrightly said it, any amount, and this 50% can be changed by the government anytime. Right now they have said it 50%, maybe in future they can do a 40%, or maybe they can do a 60% also. They have kept that right with them. But currently they have said any amount payable to the employee and the total of A to I is more than 50% of the total, it will automatically added in the wage. For example, like the A to I total, if the basic salaries of the employee, you have put it 15,000, and the total of this, the balance amount which you going to set it, you have it 25,000. Like take it 15,000 we take it, and 25,000 we take it as an other allowance. The total amount comes to be 40,000. The automatically the wage going to be become 20,000, because the total amount can't be more than 50%. Here we have the certain examples which we going to show you. Provided there is one more clause, provided further that for the purpose of equal wages, what we call it Equal Remuneration Act, Gender Equality Act, they cited for this purpose only DFGH shall be taken for the computation. When you talk about DFGH means conveyance allowance, which is highlighted in the red color, conveyance allowance, house rent allowance, remuneration pay as an avowed, and the overtime. These four allowances will going to add to check the eligibility, whether the male or female, men or women is been equally paid or not equally paid. To check the equal remuneration, the government going to add these four allowances also in the wage structure to get check the total emolument of the amount. Please move, Anima. Now the further, if they have also been decided any kind also, like some hotel industries or there are certain industries where the different types of things are being provided in kind, or in times of wages they are not going in kinds also. For that also they have a upper limit of 15%. If you are giving any part of salary in kind also. They have kept that limit of 15%, which is not morely right now prevailing in the industries. It is very less in the prevailing in the industry. So this is the wage definition, and this wage definition is applicable for the PF, for the ESIC, for your gratuity payment, for your bonus payment, for your leave encashment payment, all your labor laws. When we talk about the definition of the wage, this definition is going to be read out. Please move it, Anima.
Sure. So to sum up, just to sum up, the basic concept of the wage in the new definition is that the core wage will now comprise of your basic D and the retaining, and all the other allowances that were earlier factored in the components are explicitly excluded until unless it exceeds that 50% mark, which we call as the 50% rule. And the excess of the 50% will be added as part of the wages. Coming to the minimum wage, as you are all aware, earlier the Minimum Wage Act, the purpose of the statute was to set a benchmark in terms of the minimum wage that has to be notified by the appropriate government to as per the cost of living index. The objective was to ensure that none of the categories of the workers are exploited like they used to be done in the post independence era, because these acts are age old. So to cater those things, now the government has come up with the concept of the national floor wage, and they have also made sure that this national floor wage should be the minimum standard. Now, coming to the definition, it's defined under Section 2S, which simply states that it's the wage fixed under Section 6. So, Section 6 states that the appropriate government, they will fix the minimum wage. So, for which the appropriate government is the central government, they will fix the minimum wage. For some, for whom the state government is the appropriate government, they will be fixing the minimum wage. However, we'll see in the later slides that there is a limit that the minimum wage which the state government fixes should not be less than the national floor wage. This is a very important criteria that we have to understand, that any of the state in any of the particular employments cannot specify a minimum wage which is less than the national floor wage. Coming to the components of minimum wage, it is given in the section 7, which basically states that it has three main components. It can consist of the basic rate of wages and allowance at the rate to be adjusted at such interval and in such manner as the appropriate government may direct, to accord as nearly as practicable with the variation in the cost of living index, a basic rate of wage with or without the cost of living allowance, and the cash value of concessions in respect of supplies of essential commodities at concession rates where so authorized, or an all-inclusive rate allowing for the basic rate, the cost of living allowance, and the cash value of the concessions, if any. So what we understand is that the appropriate government, be it the central or the state, they will formulate the and fix and revise the minimum wages. And the type of work that they will revise will be the scheduled employments. It can be for the time work, it can be for the piece work. And the statute also specifies that earlier it used to tell that the wage period for a specific period would be maybe a 30 days, that is a 1 month wage period, or maybe the 14 days. There were instances of daily wage rated also, but for that it is specified that this code clearly states that the wage period can be by the hour, it can be by the day, and it can be by the month also. So this is a very important change that has come on with respect to the minimum wage. Coming to the before and after of code and wages. So as we summarized, the most important thing is unification of the definition of the term wages, and the 50% rule, which states that the basic, the retaining and the DA are the main components, and the rest allowances cannot exceed the 50% mark. Another thing that the code on wages specifically have stated are the definition of the term employee and worker. Earlier, there was a very, very common question that we used to face from all the establishment was that what is the definition of employee? Whether we are supposed to consider an employee an employer or a worker. So, employee or a worker. So these things have been clearly demarcated and defined, well defined under the new codes as to who is an employee and who is a worker, which will be taken care of in the coming slides. The minimum wage for all the employments, it was earlier for the scheduled employments, now it's for the for all the employments. And the confusion has been removed, because in the central rules we'll have to check if the state rules notify these particular employments separately or not. But the central rules, they clearly demarcate and define what are the occupation with respect to the high skilled occupation, what is the semi skilled occupation, and in the schedule it specifies as to what are the workers, in which category of employment do they fall in. Next is the national floor wage. Earlier, there was no concept of such national floor wage. There are strict payment timelines with respect to the wages. Earlier in payment of wages or the minimum wages, we could see that they were not ambiguity, but there were multiplicity of payment terms, in terms of, like, if you're employing 1,000 or more workers, you're supposed to pay by 10th. If you have less than 1,000, you're supposed to pay by 7th. If you're terminating, then maybe by the second working day. If the other person leaves, then maybe by the next pay cycle. So there were multiple payment guidelines under the old laws, which have now been taken care of and have been made more stricter, in terms of that the payment dues should be cleared within 2 working days. The mandatory equal pay, which is the Equal Remuneration Act, the same provisions have been still incorporated as it is. The ceiling of the Payment of Wages Act, which was earlier 24,000, in the state of Haryana, it was removed by notification of 2018 or so. That has been removed completely. There is no wage ceiling which defines that any worker who earns wages up to a ceiling of 24,000 will be a worker. So those type of ceilings have been completely removed and done away with. The gratuity has been exclusively and explicitly excluded from the term wages. It comes under the exclusion part. The wage settlement, as we were talking earlier, in resignation or retrenchment, is also to be done within 2 working days. The one important aspect that as an employer and establishment has to understand is that there may be some compliance formalities or maybe procedural formalities which you might think that there is no NOC from the IT department, this particular person has not handed over the laptop. So these type of procedural challenges might lead you to do the FNF at a later date. But since the penalty provisions have been made more stringent, it is advisable to work in line with the statute and try to do the FNF within 2 working days, despite of these challenges, by keeping a good paper trail and all. Other thing is the total deduction shall not exceed 50%. Earlier, it was extendable up to 75%. The salary ceiling for bonus eligibility and calculation is yet to be notified. Like earlier, as long as it's notified, we are going to follow the earlier system of 21,000 for bonus eligibility. And there's a concept of inspector cum facilitator, which basically is a new concept which the government is trying to bring in to help the employers, and not see inspectors as basically the ones who are just there to penalize the employers for non-compliances, but rather they would also guide the establishments on how a particular compliance can be done. So these are the major changes or which have been brought about by the Code on Wages before and after. As we were talking about the term employee and worker, there's a very, very thin line of difference, and we often get confused, and we use in our normal day-to-day language these terms interchangeably. But now the Code on Wages, they clearly define the term employee in section 2K and the term worker in section 2Z. The exclusion is common, which is the armed forces part. Both of them don't consider the armed forces as an employee or a worker. But in worker, they have added more components like, the one who is employed in police service or who is employed in mainly managerial capacity, administrative capacity, which are also employee. So first I'll quickly go through the definition, and then we will see as to what are the key differences to identify who is a worker and who is an employee in the next slide. So 2K defines an employee as...
Anima, we can skip.
We can skip this part? Okay.
Yeah, because it's too lengthy. We're not left with the much more time.
Okay.
Majorly the definition of the employee and worker. Okay, yeah, this is a slide. Yes, you can put it on this slide, 2 words.
Right.
So there is always a dilemma in the industry, how we can categorize or how we can quantify who will qualify as an employee or who will qualify as a worker or a workman. For that, the earlier they try to get it the certain salaries limits or certain things. So now again they want to get it more clarified it, like the supervisory control, managerial, administrative works categories can be categorized as an employee, exclude those employed mainly for managerial and administrative capacity. In this way, they want to cap it in a way. They capped it exclusions, armed forces outrightly. Other which they categorize as in worker is they put a cap for their salaries, which is right now the 15,000. But what we have been supposed it going to be next going to be notified by the government, the what is to be the salaries to identifications of the employee or worker. But here when you talk about the employee or worker, it doesn't mean of any dispute related to the issue. Here we are talking about the employee and worker, which is defined under the code of wages. It is not been related to the dispute between the employee and employee and management, and management and management. All these types of disputes will be fall under the category of the industrial relation, for which outrightly they have that categorized with the limits of the employment strength, nature of business. Upon to that, we move to the next slide, Anima.
Sure.
Advisory and the way forward, which we going to say you from the code of wages. We going to say you for all the 3 or 4 labor enactments, please check your salary structures. Please understand your salary structures. Government will going, or the inspector come facilitator will going to visit whenever the any inspection occurred, whether it is for the PFN, ESIC or minimum wages, anything, they're going to check your salaries from basic, DA and retaining allowance, and rest to be not more than 50%. When you talk about rest, means all your allowances like HRA, CCA, Mediclaim, special allowance, other allowance, any type of allowances, not to be more than 50%. Appointment letters must be reflect wage component as per the revised definition. Under the operational safety and health, it is mandatory to have the appointment letters to be issued. So now they have made the compulsory to make appointment letter to be issued. Again, the rules yet to become. It is decided, like for example, if the maximum participants from the Haryana, like for the Haryana, if the Haryana government form their rule and they in their rule itself they also accept it, the appointment letter is to be mandatory, then we require to mandatorily to issue this appointment letter, which is currently been practicing in Bangalore also. Currently in Bangalore, it's mandatory to issue this appointment letter. Then your pay compensation and allowances adjustment you have to do. Again, you have to understand your bonus policy, whether you have not make a monthly bonus as a part of the salary, because under this wage definition, you can't make the monthly bonus as a part of their salary. And further, I want to say that when I talk about restructuring of your salary, I'm not talking about your on-roll employees. I'm talking about off-roll employees as well. So the employee means all your employees. On-rolls and off-rolls means third party or a contractor employees. Ensure equal remuneration. Equal remuneration, which I understand nowadays are being compliant across the industries. There is no like that. The cases are there to be things. The certain statutory registers have been replaced, for which they have made certain mechanisms to be there to be published, and the state it depend upon, again, as we all are under the myth ki now all the registers have been abolished, we need not require to prepare the register. It is not like that. The register is required to be prepared. It depend upon how the state is going to adopt this rule. If you are operating in 5 states and all these 5 states make certain changes in their templates, so as an obligatory, so we require to maintain the things. So it depend upon how fast the other states are going to accept these rules. Once they accept these rules and they form their registers, it depend upon them then how many registers which we require to place it, or a consolidated written concept they have bring it. So it depend upon how they're going to set it. Now what we call it system process readiness. You have to check with your HRMS and the payroll tools how it going to be configured and how they're going to apply this 50% rule, because there's certain allowances going to be changed. So now you have to be check with your the compatibilities of your tools, whether the how it's been going, the companies for which we are running the payrolls, we have been done it, the we have designed our tools in a way which we can have it on those things. So please adjust your payrolls on the excluded allowances. Please guide your tools what to deduct on the allowances for ESIC, what not to be deduct on ESIC. So these allowances you have to feed them in your payroll engine to make them to be understand which the things. Maybe in future you have to be kept ensure adherence of the national floor wages concept in your payroll software itself, so that at anyhow if you are operating across India and you are already in a multiple states, so that non-compliance of the minimum wages could be happened, to make your systems in a foolproof way. They will not process the salaries if the salaries are lesser than the prescribed minimum wages. Revise the coverage of employees, which we discuss in detail in Social Security Code. It is a very big impact. Now you have to revisit your salary structures, and after revisiting, you're going to find there are a lot of new category of the employees which are going to be covered under ESIC. Further, now they have outrightly cited the digital payments to be there when you are making the payments to the employees, digital payments to be there, digital wage slips generations to be done, adoptions of the format as and when prescribed by the state government. Now you have to make your payroll engine in that robust way. Like if the state make the changes in the minimum wage slip rules to be different, so now you have to be compete in that level, and your tools has been level to meet out those compliances of those minimum wages issued of or under the Payment of Wages Act for issuance of those things. Please move, Anima. Now we quickly move to the Code of Social Security 2020, which have these the labor enactments to be in place: Employees Provident Fund, Employee State Insurance Act, Payment of Gratuity Act, Maternity Benefit Act, Employee Compensation Act, BOCW, we call it Building Other Construction Worker Welfare Cess Act. So don't get it confused for BOCW. This talk only about the cess payment of the BOCW. It not talk about the major about the part about the what is the working conditions of the BOCW. It talk about the cess 1% which you required to be paid. The Unorganized Worker Social Security Act, Employment Exchange Act, Sign Worker Acts. These are the labor enactment which they added applicabilities on the Code of Securities. It outrightly applicable to all the establishments in the first schedule of the codes, whether it has been a direct, indirect, contractor, or the fixed term employment. It is not like I think it is applicable only on the on-roll employees. It is not on the off-roll employees or a fixed term employees. It is applicable for all the employees. And now they have bring a one major changes in this contribution. Now they have made the ESI as a voluntary contribution option has been there. Like you can do a voluntary registration under the ESIC. Earlier, it has not been possible. Earlier, you've been only been required to the threshold limit of 10 or the 20 is the threshold limit, which has been mandatory to kept you as and covered under the ESIC. Now, ESI department has made the option, like similarly in the Provident Fund, to make you understand about and they have been understand for those things to make that ESI to be covered voluntary, making like a employee concerned they want to get it. And they make a one major change. If you are into the business of the hazardous business, for example, like a chemical industries or electroplating industries or any type of industries which is categorized under the hazardous, which is being defined under the under the code of OSH. What they said it, like any industry which is under the hazardous process, they are being required to be covered themselves under the ESIC, even though they have a one employee with them. So it is not like the hazardous unit have to wait it. Whether they can take it a voluntary. If they are not taking a voluntary, even though they have a one employee, it is mandatory and obligations to them to make those to cover their establishment under ESIC. Further, they have bring this new concept of the extending social security. They have bring a gig workers and a platform workers and unorganized workers for the first time under the social security, for which the department is make a portal where all the gig workers and the platform workers are mandatorily being informed to get themselves to be registered there. Once they are being registered on those portal itself, so they going to be get a benefit. So what the government has been right now created, they want to create a funds from the employer to participate for those social security schemes, like currently we have a labor welfare fund scheme. So now they have categorized, maybe the percentage has not been yet notified, but it is going to become 1 or 2% of the annual turnover of the companies. Those are into the business of the gig workers and a platform workers, those are using, or maybe the 5% of the profit of the company, which is not yet been, these percentages is not yet notified. It is the old percentage. The percentage is going to be notified by the government separately. So it's going to be impact the all the companies those are on a online processes and using the services of the gig workers and a platform workers. Anima, please take them through all the definition quickly so that they can have a just quick look on the definitions and quickly make it. Huh?
Sure, sure. Let me share the screen.
Anima, you can start, please.
Sure, sir. Okay. So coming to the implemented provisions of the code. Is my screen visible?
It is visible.
Okay. Okay. So coming to the provisions, implemented provisions of the code, just like the code on wages. Sorry, sir.
Please continue.
So for the definition, we'll have to go to the statutory code. That has not been added in this slide as of now. Am I audible? Hello.
Is there any issue so that?
Hello.
Okay, no issues. I
Am I
will continue if it's been here. Okay, these are the sections which we here want to highlight and give you the small idea about the sections, but this is more been precisely been required for the people those want to be little bit want to go in detail and want to understand about the structures of the social security. Section 1 to 4 more talk about the formations of the central board trustees, frameworks of the social securities for the PF and ESIC, and all other the governments and appointments of their officers, inspectors, and all these things. And the section 15 talks about the pension schemes and all other things. The section 7 talks about the repeal of the enactments and savings, about these labor enactments have been repealed, and the department have combined all these 9 acts together to form the code of social securities. And all the Anima, your slide has been. Can you hold your slide, Anima? It's been up and down. Please, can you hold that slide?
Sure, sir.
You can continue.
Okay. Now the repealed acts have been there, where it has been revealed how they are being required to be functioning, and their sections about the how they are going to be penalized and how their things to be done. Nima, next slide. Now these are the detailed provision. Now once you talk about the code of social securities, there certain sections have been notified in three consecutive dates, which we call it. Once it is in 2021, one has been 3rd May 2023. In 3rd May also they have implemented certain provisions, but they have not repealed those acts. So therefore the industries are not very much aware about this is to be happened. And yes, Anima, please hold it. Yeah. This is very interesting clause which we have highlighted in section 7, there is a one clause under section 164 2B, which state that whenever the government going to notify this code of social security, it can be extended for the period of 1 year till their gaps are inconsistent with the current practice and the code of social security. But the government department smartly have not notified this provision on the on this 21st of November to implemented all those things. And they have outrightly make it those things outrightly clear, else you're going to have the objective of getting those 1 year buffer period to make all your things to in process and to make all your structures and everything in place, but the government department have not notified this. So you can maybe check on the internet also the section. I am again repeated, section 164 2B. Again move it, Anima. How the before and after, what is the major impacts of the things? It depends upon the wage workers, gig workers, home-based workers, platform workers, and unorganized. Earlier, under the social securities, these definitions are not been there. Now, under the voluntary coverage, ESI, they have give the options and they can get it. The major change in the family also. In the family definition under the ESI, now they have added the father-in-law and mother-in-law to be added in the definition of the family. Earlier, in the family definition, mother-in-law and family-law, mother-in-law and the father-in-law, sorry, is not been added. Now they have make it understanding to make them to be all dependent on the insured person if the parents are not alive. Earlier, ESI is not applicable in the mines. Now they have started to be ESI to be applicable in the mines also. Earlier, they have not categorically defined under the ESI Act the coverage of the employee from home to office or office to home. But now, this time in the Act, they have outrightly under section 34(3) outrightly stated that the accident while commuting from residence to place of employment for duty or vice versa is deemed to be employment injury. It is a very benefit, a good benefit, which is outrightly been defined under the Act, when it's going to help us the employees commuting, as well as it will be in help for the employees. Those are on the riders, those are been doing certain works for the organizations and moving in the market on the bikes and the cars. So they are now been also been covered. And the coverage they have been widened with the platform and the gig workers. There is a big definition they have given for a platform and gig workers. The platform workers, those are using the technology, mobiles, phones, which even things. So they have not said rightly the contribution to be paid by the employer of these industries. They are required to be paid by like a welfare scheme. The government is bringing a welfare scheme for this platform and gig workers, where they are going to be registered and put it like the, you can say, I will say in a word, like a tax or a mandatory obligation on the employer to contribute for those things which can be there. Now the major changes under the gratuity also. Earlier the gratuity is being required only for the on-roll employees. There is no provisions is for the things to be there for the employees. Those are the for a particular fixed term employment. There is a contract employment has also been there when you have a certain government projects or you have been a certain necessity of the work for 1 year or 1.5 year. Now the government have categorically defined that fixed term employees will also going to get a benefit of the gratuity if they are been performing or doing a work under the fixed term employment under any employer for 1 year. That means if your contract is for 1.5 year or a 2 years or 3 years, you mandatorily been required to pay the gratuity to all the employees. But here is a myth also. In the industry, there is a myth that the gratuity is applicable for all the employees for 1 year. It is not like that. For the regular on-roll employees, gratuity will be payable like the similarly as it is being paid for the regular employees for the completion of the 5 years. For the payment of 1 year, it is only for the category of the employees. Those are on a fixed term employment. It is not like the employment, those are been on a 1 year. Again, you smartly see that under the contractors also now the gratuity responsibilities directly goes to the contractor itself, because under the definition of the wage, gratuity is not added. When you remember, when I talk about the definition of the wage, I have said basic DA and retaining allowance is only the wage, and A to I is not been excluded, and gratuity is being excluded. Now, so that means any labor which is being deployed through contractors to the principal employer. Earlier also it has not been there, but now this time categorically been defined. Principal employer is not responsible for the payment of gratuity for these contractor employees. The contractor employees have to pay the gratuity by their own. Then the important compliance factors have also been incorporated, like the 5 year inspection limits is to be set for the ESI and EPF. ESI limit has already been there 5 years, but under the Provident Fund, there is no limitations of the inspections of been there, or you can set it retention of the records. There is no provision under the EPF Act. Now they have bring down the EPF also to be under the limit of the 5 years, that they can't go beyond 5 years for any type of inspections. The maximum order which they can pass on against any employer not been beyond the 5 years. They have also increased certain penalties also. They have make the provisions for the career centers for the employment exchange where they can have those things. And national database has been designed. I've said it. They put it a Aadhaar based portal. Some Suvidha portal has already been there. The people have started working there on the to be registered for unorganized people can register there on the Aadhaar base. And the second thing which I have already covered is the employment injury. The to and fro from the office to home is being covered. Now, the certain benefits they want to be specified for the women's also. They said it like for the after the maternity leave, if the nature of their jobs permits and the employer agreed, so they can allow the work from home concept also. But again, there is a myth in the industry that work from home is now become a mandatory or it is a right. No, again it is a mutual consent and mutual agreement with the employer. It again depend upon the employer want to give the work from home or not. Like this, they have been added to give the clarities that there is the option is also there, so that the woman employee can apply for it, and the employer are been then justified it whether why they want to decline this work from home concept and what is the necessity why they want that employee to be come to report to the office for the work. Similarly, they have included the same maternity benefits for the registered medical workers to be there, some health to be there, nurses to be there, medical bonus earlier is also there. Now they have defined it. The medical bonus is mandatory if to be paid to the women worker for checking of their pre and postnatal care. Nursing breaks, they have defined nursing breaks. Earlier, their crutch, mandatory crutch clause has been there. Again, now they have make it a streamline in the act. I said it earlier, crutch is mandatory with 30 employees in the factory. So now they have make it the factory also be to be crutch with 50 women employees. 50 employees, even there, the crutch facilities to be there. It's not been a now a gender. Sorry, I use that word. Women employees. I again said it. It's employee. It's not a woman employee. A neutral gender. They have said it. The things. Now they have set it the registrations and the online ways to be there to ensure all the coverage of all the new employees. You have to be check it on your portal whether you have new category of the employees which going to be covered under the ASIC and PF limit. Please get them to be registered. If you are using gig and platform workers, make sure you have those gig and platform and encourage them to be registered themselves on the portal of the gig and platform workers. Further, contractors, when power managements to be defined, their real times to be there. Again, we going to read it under the Contract Labor Act also. They have defined the contract labor are not allowed for the core activities. Again, it is a myth. No contract labor are being allowed. It's not like that. The department has said it. Earlier, it is a word perennial nature. Now it is a core activities. So now what we're going to say, any business activity which is in your establishment or a factory which is not your core nature, like if you have any office, so security, housekeeping, pantries, horticulture, these are not your core business. A software development company does not, a core business is to have the security, housekeeping, pantries. So these not been required, but again, it will create a problem. Maybe if they want to hire directly a software developer through a contractor, maybe that fall under the core activities, and maybe department will not allow to engage these things. For that, they have given one more option for the fixed term employment. Now the companies can also have the employees can be hired on a fixed term employment node. Like you have a contract for 2 years, so you can hire an employee, giving him outrightly for a 2 years contract, and there is no compulsion on the employer to exceed the period of the agreement, tenure of the agreements, or the any disputes related to the employee at the times of the closure of those fixed term employments. Again, the new hit on the gratuity has been there due to the increase in the minimum wage, because indirectly your gratuity is to be paid on the basic DA and retaining allowance, and it is mandatorily to be the 50% of the total components. So now the gratuity hits is going to be increased for you for the on rolls as well as for the fixed term employees. Anima, please.
Sure. So I'll take it from here. So coming to the impact, as we all understood how the wage component varies and how it's going to affect the employers structures with respect to the wage composition, we must understand what these particular components are. Whenever we see a wage, the first thing that comes to our mind is कि as an employer हमें PF देना है, हमें gratuity भी देना पड़ेगा, bonus भी देना पड़ेगा. So we need to understand what is the impact of the code with respect to the EPF. As long as the EPF is deposited on the wage ceiling of 15,000, जो अभी तक हम कर रहे थे या most of the employers कर रहे होंगे, there is not much of an impact. But wherever the employers have kept the basic low and kept other components high, जो allowances है, which are the exclusive part, right? So with the coming of the 50% rule, accordingly the basic will increase, because what the rule of 50% is, whenever any allowance is in excess of that 50%, that excess amount will be considered as wage. So now, even if you have a lower basic, if that 50% criteria is not fulfilled, that excess will be added here, and accordingly your basic will increase, and consequently you will have to pay the PF contribution on that increased basic. Okay, so that's how it's going to be, that if you're paying the EPF on the wage ceiling of 15,000, there's not much of an impact. But if you have kept the basic lower and the other components, that is the allowances, higher, then accordingly, as per the new definition, the wage component, that is a PF wage so called, will increase, and thereafter consequently the contribution that you were paying will increase, which will automatically result in the lesser take home salary. But on the bright side, as it's clear that it leads to the higher retirement corpus. So the lower take home salary for employees whose contribution on 100% of the basic, for them it might be a concern in the short future, but in the long run, when it comes to retirement, they have a greater retirement corpus. Coming to the ESI, we could see that the ESI head office and some regional offices and the sub-regional offices, they have issued circulars regarding the implementation of the new definition. Because now what has happened, that with the change of this definition of wage into 50% rule, what we are saying is there is a possibility that who was earlier excluded from the ambit of the ESI, with the new rule, they might get covered. So we'll look at those examples later on in detail, but we just need to understand that now the ESI is proactively, all the headquarters and all the regional and the sub-regional offices, they are issuing these circulars in their areas, asking their own regional offices to make sure that the employers who were earlier outside the ambit, they must review their coverage in terms of and in light of the new definition, and ensure that if they are covered, they must get themselves covered. Also, the employees, they have to review the entire wage component of the establishment and make sure that employees who were earlier out of the coverage, because for earlier the wage we would see that okay, he's earning the total of say in and is 25,000, so he's now out of the ambit of the ESI, he's not covered. But with the new definition, we need to make sure that what will become the 50% rule, and as per that, if that basic DA and the retaining plus the excess of that 50%, if that results in the statutory threshold being covered, that will lead into the inclusivity of that particular employee. So
Okay.
these circulars mandate that the employers must ensure compliance.
Okay, the objective of adding this slide in the knowledge session is that the ESI department is acting very smart and very proactive approach. ESI head office Delhi, as well as certain regional office in the western part of the India, they have start issuing certain circulars to the employer and the labor unions, and you can say the associations, stating that the wage definition under the act, section 288, like the wage definition which I said about 2Y in the wage code and 280 in the code of social security, has been revised. So you required to check your manpower whether after the count of the 50% of the wage definition, all new entrants required to be covered from the implement of this act, that is 21st of November. For that, they have issued the letters to the regional offices to make sure that the industry is going to be compute with those compliances. So in short, that means ESI is ready for making their adherence for the wage structures to ensure that the new category of the employees which going to be covered under the ESIC, they going to be covered under the ESIC, the category number 1, and the category number 2, for those category of the employees, those are already been covered, but there is none of the employees are been covered. When you talk about this breakup, definitely in the future breakup, I will show you there the ESI contribution is going to be reduced for certain set of employees for which you are been contributing, and it is going to be new entrants to be there in the coverage. Please, Anima, move next slide. The ESI compliances which we going to say you, let me take it to you take it to example slide.
Yeah, sure.
Bring that slide later on so that they can have the understanding. Major pain is the example of the site. Okay, I have made this example for the better understanding about the salary structures. We have used the word TR. TR is a total remuneration, means a definition defined under the 288 of the Wages Act. Example 1, like Mr. A, his total monthly salary is 20,000, which is below the 21,000 threshold limit, and currently his or her basic salary is 12,000. Allowances, HRA, conveyance, other things. As I said, A to I, as per wages definition, A to I is been excluded 8,000 rupees, and total comes to the 20,000 rupees. But now, as per the category, that A and I total can't be more than 50%. So therefore, the 50% of the 20,000 is 10,000, and we have put it actually exclusions of 8,000. So that means our breakup is compliant in terms of the wages, because we mandatorily required to keep the basic DA and retaining allowance to be 10,000, and our breakup is been 12,000. So that means on the wage perspective, we are being compliant, and we required to pay the contribution on the 12,000. So I make it again a clear. There is a myth going in the WhatsApp group and the industry. Everyone is become a knowledgeable nowadays. Everyone is become a master to make it clear what is the thing. But I outrightly clear you, if you have already defined more than 50% of your basic DA and retailing allowance, you required to contribute on the the wage. The wage definition is very simple: basic, DA, and retaining allowance. Irrespective, your structure have more than 20%. If it has been not more than 15%, then you have to add back this thing. This is the first example where you are being compliant and your breakup is more than things. Now we come to the example number 2. In this example, the salary is 20,000, but your basic pay and DA and retaining is 8,000. Allowances, HRA, conveyance, other things is 12,000. Again, the total remuneration is 20,000, and the exclusion is more than 50%, that is 12,000, which would to be a 10,000 only, as the 50%, not more than 50% A to I. So that means excess exclusion is going to add back in the basic pay, which I have read it in the definition. Any amount A to I is more than 50% of the basic and DA is to be add back to the basic and DA. So here the 2000 is the excess amount which is going to be add back. So now after add back, your ESI wage is going to become a 10,000 rupees, and you required to comply on this thing. This is an example where all breakups you required to be checked. Currently, any of your employees is not having such breakup. If such breakup is there, you required to pay for all these things. And from example 1, we required only to pay for a certain amount, as we are currently paying on all 20,000. Now, here is another one example which we have make it for an employee drawing wages more than or 40,000 and currently is not covered under the ESIC. So now for example, we have assumed it, the basic salary is 16,000 and the allowances and HRA, other things, special allowance, other allowance are 24,000. Totals comes out to be the 40%. But now as I said, the allowances can't be more than 50%. So that means excess of 24,000, that is 4,000 rupees. We have given you the example. 4,000 rupees is the add back into the total wage in basic DA. So that means 16,000 plus 4,000 is become 20,000. And the ESI limit is 21,000. So therefore, all these category of the employees is going to be covered under ESIC. So I will send you particularly to all the industries, please check categorically all the salary breakups of the people up to 40 and 41,000, because all these categories are going to be covered under ESIC. So please check thoroughly. Wherever you require a support, you can connect with your the spoke from our team or the payroll team from our organization, which is going to help you out if you have certain confusions in your payroll processings or making the things. Again, make it clear, if the 40,000, you have to be basic pay, DA and RAs to be 50,000. Again, I make it one more issue. Is that 50 is mandatory limit? Can't we exceed the 50 limit also? No. You can exceed the limit more than 50 also. Again, this is also a myth going on in the industry. Again, a myth is going in the... Anima, please take it last example only. Yeah. Again, the myth is going on in the industry that it is mandatory to have a 50%. I'm saying 50% is mandatory for the wage. But if you want to keep your basic pay and DA and retaining allowance to more than 50%, no one stops you to make it more than 50%. So that you can have your salary breakups more than 50% also for the basic pay, DA and retaining allowance. And again, is a myth. Shall I require to change my breakup? I will say, if you don't want to change your breakup, don't change it. But again, if you have to contribute as per the 50% concept, because there are certain industries, those are saying we do not want to change our breakup, but we are ready to adhere on the things. But it doesn't make a difference to them, because even though you are not reducing, not want to increase the basic salary, again, all your benefits is going to be on the wage only. When all your benefits is going to be on the wage only, so then the 50% formula automatically applies to the employees. Those are having less than 50% as their basic salaries. Anima, next example. Here is an example where the total salary is 46,000 and basic pay is 20,000. Total allowance is 2646. When you add back this 46,000 to 50%, it becomes 23,000. And once it becomes 23,000, you need not require to cover this category of the employees under the ESIC, because here you get a benefit of the add back also. Like you have put it a 20,000 basic salary, 26,000 is the other allowances, but due to the benefit of the 50,000 breakup, you add 3,000 upwards and it becomes 23,000. Once it become a 23,000, you are above the threshold limit, that is 21,000. So this category of the employees will be considered as an exempted employees. Now these are the examples for the provident fund which we have created. Don't get it confused with the ESIC examples and PF examples. Now it is a provident fund example. There is an employee whose basic pay is 12,000 and allowances are 8,000. Again, the total is 20,000. 50% limit is 10,000. Actual exclusions is to be 8,000. But you have kept as in 12,000. So again, we require to be contribute on the 12,000. Not we can't make it to the 10,000. Next example, Nima. Example number 2, again, where the 50% is reduced. So you can have the 50% to be reduced to be there, which is going to be added. Again, the 50%, 2,000 rupees is going to be added and you require to be compliant on 10,000 rupees. Same examples of ESI, I have designed it so that better understanding for the PF also. Now there is example number 3. It is a little complicated example which you want to be understand because it is depend upon the industry to industry and practice to practice. For example, you have a current 12,000 basic pay and you are contributing to the PF to that category of the employees, and other allowances are 28,000 for an example. So now after this new wage definition, your basic to be a 50%, so that become a 20,000 rupees. So now once your basic is become a 20,000 rupees, now it is mandatory you to contribute the PF contribution up to the statutory limit of 15,000. Again, this is a myth going on in the industry now. The whatsoever the become the basic, you require to contribute PF on that. That is not a case. You can the still 15,000 limit is there. You can restrict the contribution of that category of the employee up to 15,000, irrespective the basic going to be 20,000. So in this case, the PF wages, the wage salary become a 20,000, but we can restrict the PF on the 15%, and the industry, those are complying on the 100% base salary, they can contribute on 20,000 also for these categories of the cases. Please move on. You. This is another act which call it Occupational Safety, Health and Worker Conditions Act, which has repealed 13 labor laws for the understanding. Please take them through, Anima.
Yeah, sure. So these basically define what should be the safety conditions of a worker or an employee working in the establishment, the health and the working conditions, and they compile all these 13 statutes, which are mainly the Factories Act, the Plantation Labor Act, Mines Act. So in most of the cases, we can see that the key acts that might affect us are the Factories Act, the Interstate Migrant Worker Act, and the Building and BOCW Act, which we did not see in the Social Security because that was expressly related to the cess, and this is not related to the cess. This is with respect to the working conditions as specified under the BOCW Act and the Contract Labor Act. So when we look at these particular legislations, we can see that these legislations are a compilation of such laws which primarily govern the type of the working conditions, the health requirements, the safety requirements, the amenities, the working hours. So those type of provisions related to a worker working in the establishments working under these particular statutes. So in some cases, we can see that there are express chapters under the code, and for some, we can see that within the same chapter, they have divided that into the parts, like part 1, part 2, part 3. So for deeper understanding, we need to visit the code to understand which chapter deals in what provisions of that particular specific statute. Coming to the applicability, as we were discussing earlier, that these codes, they have tried to be uniform through and through. So in terms of applicability of the OSH and WC code also, we can see that it applies to all establishments where any industry, trade, business, manufacturing or occupation is carried on in which 10 or more workers are employed. And these are the below categories in which this particular number might be very handy to understand the applicability, which is the factory, the motor transport undertaking, newspaper establishment, audio video production, building and other construction work, plantation and mine. As many of you are already aware that in terms of Factories Act applicability, there was a revision under the Factories Act which changed the threshold of 10 and 20, wherein 10 was with the aid of power, 20 without the aid of power, and those limits were revised later on to 20 and 40. That is, 20 was with the aid of power and 40 without the aid of power. So in these circumstances also, the applicability will almost be the same as that which was earlier. However, the threshold limit has been somehow revised under the OSH code, like for CLRA also there has been the revisions. But again, since these are the codes, the state governments will have to notify the rules under this code, and we have to see if these applicabilities will vary from state to state or not. Explicitly, what is not included or who are on whom the code are not applicable are the offices of the central government, the state government, and ships of war of any nationality. But from operational perspective, if any of these particular setup, even if it's a government establishment, if they are employing a contract labor in the establishment, then accordingly the provisions of those particular statutes will trigger and apply to them. Okay. On 31st of November, all the provisions of the Occupational Safety, Health and Working Conditions Code were notified, just like the Industrial Relations. As we saw in the Social Security and the Code of Wages, we could see the table wherein specific sections were notified to be implemented. However, with respect to this code, all the particular entire code was said to be notified, and there is no differentiation whether it's section 2 or whether it's section 5. Everything is in effect from 21st of November 2025. So what are the major differences that has come into effect after post implementation of the OSH code? The first and the foremost thing is the appointment order. So as Sachin sir specified earlier, that in a SNE setup, the requirement for giving the appointment letter was is still there in the state of Karnataka, wherein it's in Form Q. But under the Factories Act or BOSW Act or any other of the acts that we saw, the 13 acts, none of the statutes had the provision to issue appointment letter to the employees or the workers that were engaged by them in the establishment setup. Now, this has been done away with, and the provision for appointment order has been made mandatory. But again, I need to clarify, we need not panic. We have to wait for the state rules to see if what is the format of these appointment orders. If nothing has been formalized and there's a provision in under the removal of difficulties that the format as specified by the central government will prevail, then the establishments are free to follow that particular format itself. Okay. Another provision which was a game changer is the provision for single registration and common license. Now, you know, many of you have obviously engaged contractors in housekeeping, in pantry, for security, and these contractors, they provide services to multiple establishments, not only in the state but pan India. So for them, it's a very big relief, because with coming of single registration and common license requirement, now they need not apply 10 licenses for 10 different establishments. So there's a provision under the code to enable them to apply for a single registration and a single common license. And the validity of these license has also been increased. Earlier, the contractors, they had to every year apply for renewal, mostly in the month of December. But now the provision has been extended for a period of 5 years. So again, that's a big relief to these contractors as well. The earned leave eligibility, which was earlier 240 days, has now been reduced to 180 days. So this is again a relief for the employees, that their eligibility condition need not fulfill the 240 working days, but rather 180 days of continuous service to make them eligible for the EL. the amount of EL that they will earn is the same, is the 1 day for every 20 days of work performed. There's no change in this particular language, but yeah, the 180 days and has been replaced by the 240 days has been replaced by the 180 days. Now coming to the exclusive facilities for transgender. Earlier we had a different act altogether for transgender. Now seeing the inclusivity and trying these codes to be more gender inclusive, they have now provisions regarding the employment of these transgenders as well, the facilities that needs to be provided for these transgender employees as well, which has been incorporated into this particular OSH code. There has been mandatory health examination requirement, which is now a mandate, and there has been provisions where it has been specifically stated that a particular employee having means 40 years of age or more, or depending on the type of industry, like in mine, dock, or factories, the medical examination is a must. And as usual, the record for these medical examination has to be maintained, which was earlier also there in the previous act. The CLRA applicability threshold has been increased to 50. Earlier, it was very state specific. First, under the central statute, it was only 20 or more contract labors, and then the state were at the liberty to revise this particular threshold. So some of the states have revised it to 50. Some have done left it at 20 itself. In some cases there are 5 or more. So this thing has been standardized in the occupational safety code by increasing the applicability of CLRA to 50 and of ISMW from 5 to 10 now.
Okay.
Earlier in yes, sir.
Just a small thing.
Hmm.
As we said rightly, maybe I have said outrightly, in the occupational safety, health and working conditions, it is not like the occupational safety, health and working condition is only applicable to the factories. This time they have also added establishments also under the definitions of the occupational safety and health and working conditions. So they have outrightly defined certain things for the factories and certain things for the establishment. When you talk about appointment letter, they're going to be again, as I've said, the different state is going to make their rules. What is to be the template of the appointment letter? Central rules already have their appointment letter template in which they required to be mentioned their rules and regulations and their salaries breakup to be there. When you talk about the common registration, outrightly said, when you have the single registration means for the BUCW, for the principal employer registration, CLRA, for the PFESI will going to same continue for the factories, interstate migrant, you can have a single registration from the Shram Suvidha portal. Earlier, once you've been there to apply for the new entrants, they required to be covered under the avail the new leaves. They required a 240 days buffer period. They required to wait for the apply for their new leaves. Now, as per this new law, you can have a 180 days the waiting period. After 180 days, you can apply it for the leaves and which you can set it. Again, there are certain health examinations are become mandatory for the employees for certain category of the employees under the factory and certain age of the employees for the category of the employees to be medically check up in every year. So now earlier these types of the categories is only for the hazardous, but apart from the hazardous, now it become for the category of the establishments and the factories, as well as it is category on the employees count also and the age also. CLRA applicabilities. Every state have a different look. For example, Telangana is being applicable for 5 employees. Haryana it is 50 employees. Somewhere Delhi is 20 employees. So every state have their own thing. So government has tried to make a standardized CLRA applicability 50 to all the things. Again, the prohibition of which we have already talked about a software example I have taken. The department has stopped you from the core activities. It does not want to allow you a core activities. Apart from closing a core activities, they have given you the option for the fixed term employment. You can use that option to be as in category of the workman. Earlier, the contractor have to take a different licenses across India. How it's going to be implemented, I am also confused. But now they are saying that we are going to issue a central license for the contractors for working in multiple states. Let's see how it's going to be work out, but the department objective is to be standardizing them as the contractor required to deposit the security at every state. Now they have come up with the bank guarantee option. The contractor can give the bank guarantee for the license fee, which they can able to reimburse at the end of the closure of the things. Interstate migrant workers is also been directly for the contract workers would be there. Now the even the directly employed workers, we fall under the interstate migrant worker definition. Next slide, Nirma. Here is a small comparison which we want to avail it. Like earlier, 188 is 240 days reduced. Entitlement of the leaves same. Earlier, under the codes, you can take the leaves in the next year. Now in this code, you can avail the leaves in current year also. Again, this is going to be impact. Earlier, the encashment of the earned leave is only at the time of discharge, dismissal, resignation, or in case of death. But now, if any employee whose EL is exceed 30, it is being required to be encashed in the same year by the employer. So that I'm not saying the upper limit you can't have to reduce to 30 if you have already have a better facility of the 30 and more than exceeding the 45, but there must not be a provision of the lapse of the leaves. If you any leaves you make it, whether you make it 45 or 50 or 60 EL, but there must not a provision of the lapse. Now you can't lapse any leaves EL to the employees. Now you're required to be encashed after the 30 leaves. For example, in my kitty, it have a 40 leaves, so then 10 leaves required to be encashed on it in this year, and 30 is going to be carried forward in the next coming year. Next slide. This is the small comparisons for the factories. Maybe you able to understand it earlier. Canteen is mandatory in the factory after you have a 250 or more. Now the strength threshold limit has been reduced to 100. Crutch is earlier on 30, now it is on 50. The bathing, fest thing, clock rooms are all been there. First aid box have been ambulance room, been earlier been there for the factories. Restroom for the employees is required at 150 employees, but now they have reduced the drastically to 50 employees also. Welfare officers on 50 employees, now it is to be on 250 employees. Safety officer, earlier it was on 30 or earlier on is 1,000 employees, now it is on a 500 employees. Safety committee is on 500 or more workers, earlier it is for a 250 workers. Similarly, certain provisions is on the establishments also. Advisory on onboards for the way forwards, which as we said it, government is going to 6 months period for putting all your registrations together. When I talk about all registration means your factory license, your CLRA license, your interstate migrant worker license, all these. I'm not talking about PF and ESI. PF and ESI is going to be continue as it has been there because it is already mapped with the Shram Suvidha portal, already mapped. Then again a very important things for the corporates that they have started a 12 hours rule for a day. Now the department said you can have a 12 hours a day work rule for the employees. It's not mandatory, only you have a 8 hours. That means you have a 48 hours kitty for a week, which you can split as per your requirement. The maximum can't be exceed to 12 hours. Earlier it has been 8 hours and maximum after taking the special approval, it is going to 10 hours only. But now department in the act itself states that you can have a 12 hours work. But again, I am saying that it is under this code only. The Shop Act is going to be separately to be contained working hours. So maybe the different state governments Shop Act going to be changed and they also incorporated this clause, which we can't comment right now because the Shops and Commercial Establishment Act, again, it is with the preview and with the right of the state government. Central government does not have any much more interference under the Shops and Commercial Establishment Act. Again, I said it, the contract labors you can't have into the core activities and on those things. Please move. Again, take it for the industrial relations things. Anima, take it to the...
Yeah, sure. So coming to the industrial relations, it's a compilation of the three main statutes, which is the Trade Unions Act, which contained provisions regarding the constitution of trade union, how they can register, how they can raise a dispute, and so on and so forth. The Industrial Employment Standing Orders Act, which was again earlier applicable to industrial establishments only, which was defined under the Act be a very specific category of establishments and did not include a SNE. Haryana was the only state which categorically and explicitly included a shop and commercial establishment under the Standing Order Act. Okay, and the provisions of this act particularly, they define and govern the terms and conditions, or you can say it's a rule book for a particular establishment to follow in terms of the working of their workers. So the trade unions, the Standing Order, and the Industrial Dispute Act, which we used to very clearly specify, that is only applicable when there's a dispute between a worker and an employer and an employer and an employee, and worker. So any type of these disputes were covered in the Industrial Dispute Act, which contain provisions regarding the strikes, the lockouts, the layoffs, and the retrenchment. So all these things have been compiled under the Industrial Relations Code. It contains and it unifies the legal framework as to how a trade union is to be set up, what should be the employment conditions, how a particular industrial dispute is to be investigated, and it has to be redressed. So again, as the OSH code, all the provisions of the IR code were also notified to come into effect from 21st of November. There is no differentiation as to what is in effect and what is not. The entire code is now implemented. Coming to the applicability, again, it's a mix of all the laws of all the three industrial laws which you just saw. So it applies to all the industrial establishments and undertaking where any industry is carried on. The important thing is that this particular statute has given a more wider definition to the term industry to avoid ambiguity as to what should and should not be included in an industry. It's a very wide term. So for that, we need to see each case as to the difference is basically very minimal, which removes the gap as to what should and should not be an industry. And technically, anything which does a business will be considered as an industry subject to certain conditions, which is a 3-point rule, which we'll take care of later on. It covers all the employers, employees, and workers. Since in this, again, there's no differentiation. Earlier we used to say ki if a particular employee is not a worker, the provisions of the ID Act will not apply. So we did not give him the retrenchment compensation. So those things are again explicitly taken care of and defined very clearly as to who will be an employee, who will be a worker, who will be eligible for retrenchment compensation, what are the rules for the strikes and all. So all these things are taken care of under the Industrial Relations Code. It applies to all matters relating to trade unions, conditions of employment, industrial disputes, standing order, and is effective from the date notified, that is the 21st of November. So what are the key changes? The major change is with respect to the applicability of the standing order. Earlier, the count was 100 or more, and this count has now been revised to 300 or more employees. Please mind, it's employees and not workers. And also, again, Haryana was very different in this aspect, because in Haryana, the standing order was applicable on 50 or more employees. So these things we need to understand whether with the state rules these things will change or not. We need to see, whether we need to wait and watch if these things affect the applicability once the state rules come in. Again, another change was the layoff and the retrenchment clause under the IRC 2020, in which 20 or 50 or less workers are eligible. That not eligible. The criteria is 50 or less workers for retrenching or laying off a particular from a establishment. They need not used to require an approval. Earlier, whenever we used to lay off or retrench a specific number, that is, it was first 100 or more. Those numbers have now been revised. The layoff and the retrenchment exemptions to establishments with less than 50, they need not take any type of approval, any type of permission if they are laying off or retrenching anybody. So consequently, there is no question of even the retrenchment compensation. And this is also exempted to seasonal industrial establishments. Coming to the approval, as we were speaking that earlier, for retrenching or laying off 100 or more workmen, there need to be a set of guidelines that you need to submit a form, a particular form or notice to the government. You need to send notice to the workers and take approval and then proceed with these layoffs and retrenchment. But now this particular threshold has been increased from 100 workmen to 300 workmen. And for that, we need to obtain government approval. So the formats in which these approvals needs to be obtained will again be notified under the state rules. The coming to the notice period, the 30 plus worker notice period is applied for here, and there's a provision for negotiating council. And there's a concept here that whenever there's a dispute, and if the number of workers in the dispute are fulfill that particular threshold criteria, they need to go through that negotiating council. Otherwise, the factories can have their own GRCs, that is the Grievance Redressal Committee, which was also there in the ID Act earlier, the provisions under Section 9 and all. So those things can be taken care of through the negotiating council and the GRCs, that is the Grievance Redressal Dispute Committee. Coming to the reskilling fund.
We have to move fast.
Yeah, time. I think there are just 2 and 3 slides. Yeah, sure. So coming to the reskilling fund, this is a new provision that has been added into the IRC code, which basically is kind of a fund which helps the retrenched employee in terms of his skill development. So the before and after changes will quickly go through. All the things have already been explained. That is the standing
Anima, your
order.
voice is not audible. Let me continue.
Sure.
Let me continue. Yeah. Okay. So now which we said it, industrial relation codes, like the standing order, it has been applicable on the 100 manpower. Now it is being on the 300 plus manpower. The certain approvals is like the things, the deemed approval before, now deemed approval will be going to be in 60 days. Now they have a certain provision for the fixed term employment. Now they have created a reskilling funds for retrenchment worker. Earlier there is no skilling fund has been there. Earlier there is no compounding of the offense has been permissible. Like the all other, apart from labor law, there are certain acts are there in India in which the compounding of the penalties can be done. Now the grievance redressal committee to have maximum 10 members. Earlier it have a 6 members. Early this strikes lockout provisions are more stringent and very specifically about things. Now the closure of the establishment very easy. Earlier it is for 100 count. You required to be take a permission for more than 100 employee establishment. You required to take a permission from the government or from the respective DLC and the additional labor commissioner. Now the count have been increased to 300. Like below 300, you need not require any approval if you are been planning to close down your establishments or permissions for the layoff or something like that. The time period of filing grievances, earlier it is 3 years. Now the grievance is only for a 1 year, and industrial dispute, raising an industrial dispute period is also defined for 2 years only. So now what we require to be advisory, like the standing orders, if you require to please get it certified if been there. If you are not been there, so please recheck your eligibility. Make it a government grievance redressal committee, so that make it things to be there. Again, plan it for all these things of the retrenchment process to be rechecked, and reskilling funds. Reskilling funds details have yet to be published by the department. Who is going to be the reskilling fund managers and what should be the percentage to be contribute? They have not yet now been notified by the department how it's to be there. This is the small penalties which we have to be in the new labor codes and the earlier labor codes. Like the fines have been very categorically been defined under the Payment of Bonus Act. It is earlier 1,000 rupees. Now it is going to be 20,000 rupees. Under the equal remuneration, it is 10,000. Now it is 20,000. Employee state insurance drastically been increased. Earlier it is 4,000. Now it is 50,000, and imprisonment clause is 1 to 3 years. Employees Provident Fund, again, the 4,000 penalty amount has been increased to 50,000 to 1 lakh. These penalties we talk about, like if there is a non-production of record, something types of the prosecutions are launched by the department against the employer. So these allowances are being categorized, which has not been benefited by the employees. Similarly, under the Factories Act, it is very, very high. Earlier, it is maximum 1 lakh rupees. Now it is a minimum 5 lakh rupees. It is a very, very sharp and the very cutting edge cost to be by the factories. Now factories required to be on the safety and health very, very specific and very, very categorized. They have to work out on their safety and health provision as it has been up to the maximum 1 lakh rupees, but now it is a 5 lakh rupees, a very big amount. Under the Contract Labor Act, it has been 4,000, and now it has been to 2 lakhs to 3 lakhs rupees. Industrial dispute again raised to 550,000 to 1 lakh rupees. Next slide. Now, this is very important for you to understand. Is the all the labor enactments are been there, or again you required to comply it? Yes, there are different labor laws still been there, which has not been yet been added in this or not been, like Industrial Establishment Act, which we got about National Festival Holiday Act, which has not been yet repealed or not been considered. Payment of subsistence allowance, which has been there in certain states, which has not been yet added there. Shops and Establishment Act of the state, again it is a state directive, they will take their own calls. Labor welfare funds, again a state subject, state will form their rules, state will make their own acts. Professional trade calling acts like the PTV going to deposit. House rent allowance, minimum house rent allowance, which has been again in Maharashtra, certain in West Bengal has been there. The minimum house rent allowance is to be there. So now, which has not been yet been repealed, so now it is again state. Child and Adolescent Act, which is again no child labor has been permitted. So no, again this act is not much more working in there, but again they have not repealed this act. POSH, we call it Prevention of Sexual Harassment Act. Again, it is in place, not been replaced in any act. It has been worked independently. Apprentice Act, again it has not been taken care of in these labor laws. Again, they are being kept separately for the things. So these are the labor laws which has not been kept for the things. And these are the 29 which you talk about. 29 labor laws are being there for which we required to be things. To the major takeaway for this new labor codes is to you have to restructuring where your wage components. You have to check your PF, ESI, gratuity, and leave encashment liabilities so that you can have to check with the managements. And also you can have your redesigns, your HRMS and your payroll engines so that all the calculations can be intact and in place, nothing to be there. Contractors and the vendors compliance to be there. And you have to be ready with the documentations and inspections and about the readiness challenges about those things. This is the small about these today presentations. We have a lot of questions which we have received. We will set to the Jugbir will going to ask these questions. Okay. Okay. And the another point, let me have those things. Okay, give the another slide. Okay, as you people are aware about, we have a lot of automation tools are being there to make these things, and you need not have to worry.
There's some issue with you.
The vendor compliance tool and this server comply, which we are being for the new labor codes and already in place for all the existing clients. You need not have to worry. All the compliance tools.
Animaji, please continue. Sachin sir, I think I have some network
There
problem.
was some network issue. I was not able to hear him clearly. So to conclude and just to sum up, the main thing that will affect you all is the 50% rule, and you need not worry much on that and not panic as to kaise karna hai, kya karna hai. We, as your compliance partner, are going to take care of everything for you. We have the tools in place to understand how we are going to take care of these vendor compliances, the agreements that you need to review. There's a phase-wise setup in which you need to understand first as to where, as establishment, you need to make those changes. As we gave specified in the implementation plan, as to how you can first of all analyze, you have to make sure to review your wage structure, you have to make sure to review and make changes to your appointment letters, to your policies, the contractor agreements, because as an employer, you have to make those changes, and as an employer, even the contractors with whom you have engaged those services, they need to make those changes as well. So you need to make sure that all these things are in place, and we can do that by the help of the technology as well, which we have the vendor compliance, we have the CERL comply, we have CERL notifications. Jagviji, if you can just elaborate on these services as to how we can help them in
And
a
we
just
can
in
take
a
the
minute or
questions also, Anima, quickly, na?
yeah, and
We
please,
have
we are already running short of time. So sorry it took so long, but the topic was so exhaustive we couldn't help it. So please don't hesitate to put on your questions in the chat mode, and we will reach out to you via email and respond to your queries if not taken care of right now. Jagviji, over to
Jugvir,
you.
if you have the question, please quickly ask it. I can address it quickly so that the questions help others, participants also to understand those queries. Am I
Sure,
audible
sir.
to you?
Yes,
There
sir,
are
now you're
more
audible.
questions. Point up for important question. One of question that in case minimum wage are notified or floor wage notified, how should employer determine gross wage? Do we need verification of wage in 50% like basic plus D and 50% in other allowance, which will we comply with the new definition of wage?
Okay, what I understand from this question, maybe the participant want to ask, क्या हम मिनिमम वेजेस को बाइफरफिकेट कर सकते हैं? Maybe.
Yes, sir.
Maybe this is the
Yes, sir.
question with the employed. So I will say no, you can't bifurcate the minimum wages. Under the Minimum Wages Act, they have defined the definition of the basic and the cost of living. So they have not defined HRA, other and special allowance under the Minimum Wages Act. What they going to do it? They have to do it as the minimum floor wages is going to be implemented by the any state government. They require to comply to those categories of the minimum wage as in basic salary to avoid any risk or to make the things. And the 50%, you can't say you can keep the minimum wages as in 50%. Minimum wages to be kept as in basic, and the other components you can have the 50% over and above of the basic salaries, keeping that category which I have said it A to I, total is not to be more than basic wages. This is to
Thank you,
be.
sir. The next question is, can a special allowance to be part of that definition A to I?
Yes, special allowance, other allowance are to be the part of A to I. So you can have the allowances, the special allowance and others. They have used the word special defray expenses. Special defray expenses means special allowance or other allowance. You can give the special allowance again, but the special allowance will consider in the count from A to I, not for the basic salary.
अच्छा सर, जैसे डेफिनेशन में बताया कि अगर ग्रोस सैलरी जिसकी 40,000 है और 50% पे लेके जाएंगे तो वो ईएसआई में कवर हो जाएगा। तो क्या ईएसआई में उसको कवर करना जरूरी है या क्या पॉसिबिलिटी?
Yes, I have said with that example also. Again, I make it clear, and it is a very, I will appreciate whosoever raised this question in the today's webinar. Again, it is a very important question. Any employee whose current salary is, let's take an example, 35,000, 30,000, or 40,000, any of these salaries, and the basic amount of the amount is less than 21K. So it's mandatorily been required to become the member of ESIC till 21K is the salary. So now you have to check it. If your total emolument is 40,000, you make it basic 20,000, so it automatically become to the member of the ESIC and required to make him the member.
ईएसआई में बोलो जाके 10 डेज के अंदर अंदर किसी आईपी को रजिस्टर्ड करना है। एक्ट तो 21 नवंबर से एप्लीकेबल हो चुका है, तो कब तक कोई रिलैक्सेशन है इसको कराने के लिए या कोई टाइमिंग?
Yeah. Again, that's why I have added particularly that ESIC circulars, because ESI department have started circulars stating that for the compliance of these new wage definition, and therefore they have raised the circular you required to be make a compliance from 21st November, and the 10 days infancy period has not been added or decreased. Within 10 days, you require to take the insurance number. But I want to add one more scheme here, which I have not added in the PPT. The ESI department has started a scheme of promoting the what we call it SPREE, scheme promoting of registration of employee and employer from 1st of July to 31st of December. That means any establishment, those are not registered under ESIC, and they will get themselves registered under ESIC. Their past inspection will not happen. Point one. Any employee, if you make him the member of the ESIC from today, so they will not get their ask the claim from their date of joining. What I want to say, you have asked a good question from the participant had to ask that if you make a, for example, this breakup you work out in a day or a 2 or a 3 days, and you comes out that these 10-15 employees required to be make a member, please make them a member of ESIC before 31st December, so that the hidden liability from 21st November to till date will not be claimed by the department. Please take a benefit of this scheme. Anima, make sure that we will release a separate advisory note.
Sure,
The
sir.
question asked by the participant, we please make a special advisory note for all the companies that take a benefit of this pre-screen scheme promoting registration of employee and employer before 31st December, and the risk from 21st November to till date is been zero, and so that all the employees become a member of the ESIC by the benefit of these scheme. And even those employers also, those have not taken a registration, assuming because we have done, none of employees are fall under ESIC, we need not require. But now after this new breakup, there 1, 2, 3 employees are become a member. So please take the registration at the earliest to avoid future inspections also. Please, Jugbir, another question.
Next question is that if an IT company, can IT company hire software developer on contractor role, because they are in also in IT and software development company?
Okay, so as I have also tried to cover up this question in my things, you are not been right now, you are not been permissible to take the contract labor for your core activities. Now the core activities is again a very big word. So core activities is going to be defined. What is your nature of your business? What is the memorandum of article of association going to say that what you going to do? What is your nature of business? In main core business, they are not allowing you right now, but maybe how the labor department going to act on it, we are not able to comment it, whether the state government will exclude this clause or the state government will going to cancel the contractors RCs which is already been issued to the companies. It depend upon the how it comes to be thing, but definitely work out internally to be things or try to way out of fixed term employment.
अच्छा सर, आपके हिसाब से फिक्स टर्म एम्प्लॉय बेटर है या कॉन्ट्रैक्ट लेबर बेटर है?
Okay.
काफी बोल रहे हैं कि फिक्स टर्म हायर कर लो, फिक्स टर्म में ज्यादा कॉम्प्लिकेशन नहीं है, कुछ कह रहे कि नहीं कॉन्ट्रैक्ट लेबर ही ठीक है, तो दोनों से विच वन बेस्ट?
Okay, a very tricky question. For the fixed term employment, you are being defined outrightly. The definition outrightly state that you have a fixed period. So the length of the service or the termination is easy. You can read it and you can have it. But everyone in the myth is going on in the industry. Please hire fixed term employee. But I have a one more different views for the fixed term employees. They have said it, the benefits of these fixed term employees is been equal to the on roll employees or a permanent employees. Once you talk about the benefits of the permanent employee means the all the salaries and other things, but under the fixed term employee there is a word called other benefits, but they have not defined the benefits. Or what do you mean by other? The other benefits can be n number of nature which you are giving to the on-roll employees or permanent employees. Because of that word other benefits, it is a tricky to use that word, because other benefits also states about any settlement which is happened between the employer and employee. For example, you have a dispute of anything with the employee, and you have got a particular settlement of that employee. That settlement will consider like the other benefit. Maybe the fixed term employees in going to future going to ask these types of benefit, to be cautious about the fixed term employees also, to be defined their structures and their benefits. I think the questions are more, Jukbir, or we can close down for the.
More question. I think we have to then reply. Time is over.
Yeah, please, we will answer those questions over the
One
mail.
last question can be attended. For existing employee or current employee, the appointment letter to be issued revised or the same can be continued.
No, for appointment letter, I will going to say, please wait for it. Please change the wage structures, and you can issue the letter for the wage structures. I will say another 30-40 days. They are saying they are coming with the rules. So maybe the Haryana and Delhi, like the NCR business people or the any of the state government is going to be have their rules. Once the rules are been there, they required to be issued fresh appointment letters as per those things. So I will not say in hurry issue the fresh appointment letter. Kindly change the wage structure and intimate them about this wage structure changes.
The question list are more. Is the 1 year gratuity rule applicable to contract employee? For example, if we have a project duration for 1.3 year or 6 months, would gratuity to be payable in such cases?
If you have a contract
It's
of
related to
1.2,
contract employees. Yes.
no, for a contract employees, for the contractors employees, you need not be categorized to be paid under the principal employer. You are only responsible for the wages under the Labor Act, and for the wages of clarity, they have outrightly kept gratuity and bonus out of the purview of the wage. Wage definition, again, I am reminding, only the basic DA and retaining allowance. Okay, Jugbir, I think the rest.
I think we'll have to wrap up because
But
we're
I
already
will
exceeding our
question list,
time.
मेरे पास क्वेश्चन लिस्ट काफी लंबी है तो मैं
Question-
चलो मैं फिर
So-
बाद में आपको समराइज करके दे दूँ.
So we can do one thing that
ठीक
we can just see the common queries. We can club them and make single query, and we can respond to the recipients from whom we have received those queries, and we can respond them over the email, and we can take care of that later on.
Sure, Anima ji. Thanks,
Thank you
sir.
so
Thank you,
much.
Anima ji.
Thank you so much, sir, for your insightful take on this wage codes, because I know from legal perspective it was very linear, but yeah, from compliance and the practical perspective, you have given a very nice overview and a very good clarity on how these changes are going to affect the wage definition and the components. Thank you so much. Thank you all the participants for joining and staying with us for such long duration. And I hope you could.
अनिमा जी,
this was
आप
helpful for
ऐसे
you.
सेशन इस पे थोड़ा और करते रहिए क्योंकि अभी हमें और क्लैरिटी की रिक्वायरमेंट है इस पे.
Next time I'll ensure to take in the compliance perspective as well. Yeah,
Yeah,
sure.
I take a leave. I have another meeting schedule. Okay.
Sure. Thank you so much, sir. Thank you, everyone. Thanks a lot. Yeah. Okay.